Ready? Start. Para. The Bank of Baroda filed summary suit number 2949 of 1996 against Mr. Dawood and Company, Sadaruddin Hussain and Shohin for recovery of certain amount of money. The respondents were granted unconditional leave to defend the suit by the order dated 15/4/1998 passed in summons for judgment number 580 of 1996. This order was challenged by the petitioner Bank of Baroda by filing special leave petition number 2730 of 1999, which was renumbered as Civil Appeal number 4138 of 1999. During the pendency of the appeal, the parties arrived at a settlement. The minutes of the decree were drawn and the same were placed on record by the order dated 28/7/1999. The appeal was disposed of with a direction that there shall be a decree in terms of the minutes of the decree drawn by learned counsel for the parties. As per the said consent terms, the parties inter alia agreed that the respondents would pay to the petitioner rupees 2 crore 44 lakh 71,616 and rupees 2 crore 40 lakh 69,447, together with interest thereon as specified in accordance with the schedule of installments mentioned in paras 3 in bracket A and 4 in bracket A respectively of the said order. It was further agreed between the parties that in the event of default by the respondents to abide by the said consent terms as per clauses 3 and 4, the remaining amount shall forthwith become due and payable, and the petitioner will become entitled to execute the decree. Clauses 5 in bracket A, 5 in bracket B, 7 and 9 of the consent terms which are relevant are being reproduced below. Para. The properties, namely at Warsaw and Alibag, mentioned in the order dated 6th May 1988, shall remain under attachment in execution till the decree, as set out in clause 2 herein above, is fully satisfied. In case of decrees becoming executable as provided in clauses 3 or 4 above, the said properties at Warsaw and Alibag, or any one of them as may be required, be sold in execution of the decree by the court receiver of the High Court of Bombay. The court receiver is hereby appointed in execution. He shall, however, proceed only if default is committed in clauses 3 and 4 above. Leave to execute the decree under Rule 314 of Bombay High Court rules is granted. The court receiver to pay over the net sale proceed to the plaintiff in or towards satisfaction of the decree. Herein there are other suits against the defendant in which attachment before judgment order and or injunctions are passed inter alia in respect of the said properties. However, the same will not affect the sale, which will be in execution of the decrees passed herein. Para. The defendants undertake not to sell, mortgage, alienate, encumber or charge the said properties described herein above to anyone until the decree as per clause 2 above is satisfied. All the orders passed in suit number 2949 of 1996 and the proceedings therein, including the summons for judgment number 580 of 1996, review petition number 36 of 1998, and appeal numbers 540 and 543 of 1998 are set aside, and the said suit and all proceedings connected therewith are disposed of in terms of this order. International Bank had also filed summary suit number 5471 of 1996 against Mr. Daoud and Company and the respondents for recovery of certain amount in Bombay High Court against an order passed in summons for judgment number 493 of 1997 in the said suit. An appeal was preferred by Mr. Daoud and Company and others before the division bench, wherein the parties entered into a settlement. The appeal was disposed of in terms of the consent terms by the order dated 5/10/1999, which reads as under. Undertaking given to this court by the appellants in terms of consent terms is accepted. The consent terms taken on record and marked 10. The appeal is disposed of in terms of the consent terms which could be binding on the parties. Stop.